So hello everyone. Thank you, Aurelia, for introduction, and thank you, Lithuanian Games Development Association, for invitation to participate in this conference as a speaker. Because like all of our speakers, I believe that to discuss about the importance of intellectual property in all industrial sectors is important, and in games sector too. So I represent a public sector. I am acting head of Inventions Division. And today I'll do my best to convince you that patents in game industry is not the king's trap, but it's just a new normal. And today I'll try to talk to you a bit much about patentable and not patentable objects in gaming industry with examples from gaming businesses, to navigate a bit through deep waters of intellectual property in gaming industry, to give you some practical examples of patenting in your industry, and to convince you that intellectual property is not the problem, and it's not very even difficult to understand, but sometimes it's one of the solutions or even the only one. And my question is, can you patent an idea? Would it be very wrong if I say that the ultimately interesting and engaging video game comes first from the idea, not from seeking for financial benefits, but from the idea, and from the person who's engaged in his idea and try to develop it. And from that idea, it comes a tangible product which can be protected under intellectual property laws. Sometimes this idea is very crazy. And not all ideas can be protected under intellectual property laws. And a lot of businesses strive to decide whether it's worth patent an idea or just register a trademark or a design. And first of all, that idea must take on some kind of material experience before it can be registered. If an idea is an invention, then this idea must meet several criteria to meet certain requirements to be named as an invention and as a patent. And all the inventions in all the sectors can be patented if they are new, involve an inventive step, and are susceptible of industrial application. And it's not so good understandable. What does it mean, new? And under our laws and laws of European Union, this inventive step, this criteria of novelty should be global novelty. And it means that the invention is not known in the state of art. The inventive step means that it should be not obvious for the specialists of this area. And industrial applicability means that it can be made, it can be used in technology, in industry, in agriculture, in health, and other spheres. If the object of invention is a process, legal protection by the patent shall also be granted to the product produced by means of that process. And every patent is limited in time and territory. So if a creator creates an idea, and we all know that there are a lot of ideas that's flying, yes? And it could be the situation that several creators in different places of the world, working in the same sector, they think about the same thought, they get the same idea. It's very important who will patent this idea first, because who comes first, that one gets the protection by the name of the state. And when we come to gaming industry, we should know that not all inventions in all areas could be patented. And not only Lithuanian patent law, but other laws too, they exclude some things from the patenting. And why these things are excluded? Some of them, they're just related with other values, like society's right to know, society's right to progress, and a patent would be a limitation from that. Other things are related with other areas of intellectual property. You could not patent programs for computers if it is protected under copyright. You could not patent a design of a product if it could be registered as a registered design. And so there are several forms of intellectual property which can be used if the idea is excluded from the patenting under these objects. So another question is how to navigate intellectual property in the gaming industry. And for me, it was very good explanation from experienced IP entrepreneur. I've heard that when he said that businesses, they don't have intellectual property problems. Usually they have business problems, and they just strive to solve these problems. And environment of innovation, and gaming industry is especially related with innovation, it takes place in very volatile, uncertain, complex, and ambiguous environment. And just could you imagine a worst scenario when your idea was stolen by an infringer and you have to protect yourself and to go to court and be prosecuted for without being an owner of your own patent. These situations are very difficult for all the businesses, and especially for small and medium enterprises and startups. And so in gaming industry, we can find prominent names who protect their intellectual property, very accurate, very active. And I'll just analyze databases from European Union. TMView, trademark database, TMView design database, and EPO's European Patent Organizational Register. And what I found about the Nintendo company. So this very prominent company has more than 1,000 trademarks registered only in Europe. And they have about 700 registrations under design law, like registered designs. And in the European Patent Register, we can find about 900 results about registered and still valid patents by this company. So how can it be? If games are not patentable, like mathematical methods, rules of games, schemes, are excluded from patenting, how can it be that such a big company has such a lot patented objects? And I would like to read you one example about different game, classical game. I would like to tell you a story about Rubik's Cube. And the Rubik's Cube was invented in 1974 by Hungarian architect Enzo Rubik. And initially it was called Magic Cube. And several years ago, the company Ideal Toy Company started distributing the game internationally, named as Rubik Cube. So it's classical game, but first of all, it was patented in Hungary and then in USA. After many years, of course, the patent lapsed, but I'd like to read how it was patented, what was the abstract of a Rubik's Cube, and what was patented under Rubik's Cube patent. It was 8 cube-type pieces magnetically engaged to form of cube-type assembly with educational and entertaining features. The cubes are adapted to rotate in complementary sets of 4 about one of the three mutually perpendicular axes. Each cube has colored surfaces, and when properly arranged, one distinct color on each of the 6 faces is presented. Each set shares one face of the assembly may be rotated in multiples of 90 degrees with respect to the other set. If the assembly is initially arranged properly and then disarranged by a random sequence of rotations, it then serves as a device whose object is the restoration of the original arrangement. So, when we talk about classical games, then we come to very strict mechanical features, I'd say. And what Nintendo protects under the patent? Of course, I have here only examples about the name of the invention. But as you see, it is protected device and controller, information processing system, communication method, communication program, game program, processing system, and processing methods. Feels like it should be excluded from the patenting, or not. This is the drawings from the patent by Supercell company, how they patented graphical user interface for a gaming system. And here we get the answer. What could be patented by the player of gaming industry? Only certain things can be patented, and it should be technical solutions like new algorithms, processing techniques, AI solutions, new ways of optimizing game performance, and others. Game mechanics, and it's an answer to a question of our participant, yes, that game mechanics are patentable. Software algorithms, physical world simulation technologies, new algorithms for generating graphics, also user interface innovations, technological solutions related to the game economy. So, as you know, the game itself as a whole can't be patented, but there are a lot of, game is a complex object, and certain parts of the game could be patented. And if you are not convinced that you should try to patent certain parts of a game, I'll just write that and want to introduce that this information that for SMEs, it's crucially important to think about their IPRs, because they have successfully achieved financial gains only they have registered intellectual property, and the numbers are higher than that SMEs that don't have registered industrial property. And IP landscape in gaming is likely to be complex and dynamic. Everyone involved in industry, developers, hardware and manufacturers, and even players need to consider how they are affected by IP issues and consider what steps to take to make sure they are protected. There are big opportunities in this sector, and IP management will be critical to be successful. And these things in IP management, they are important for several reasons. If you, as an SME, have a protected IPR, so you have your boundaries with your clients, boundaries with your competitors, and you have a point, and a very important thing what you can take with you when you go to investors and seek for financial support. There are two types, good decisions and lessons learned. And these lessons learned are related with disputes, of course. And I'll show you just several cases, very famous cases between businesses in gaming sector. And all these disputes were in USA. And they are related with licensing, with negotiations, with obligations, and always it is related with finance. In the case between Valve and Activision, the outcome was that although the financial terms that were not disclosed, it highlighted the growing tension in the digital distribution of games, especially as platforms like Steam gain dominance. So we understand very well that in this area, competition every day is stronger. So only patented idea could benefit from business to business to gain success and financial situation. The third case was by Immersial Corporation and Sony Computer Entertainment about patent infringement on vibration technology. And this technology, as I know, is very popular in PlayStation. And the outcome was that the company they make just an agreement to explore the inclusion of immersion technology in PlayStation format products. And when it comes to disputes, there are several forms of it. And as we know, game industry is international business, yes? And we can't rely only on national institutions and national courts. And if it's extraterritorially business, so we should know about the institutions that try to help to businesses resolve their disputes in the international area. So I come to the end of my presentation, and I just wanted to share you one experience from my life. I have a 10-year-old son, and he likes Minecraft very much. And after he gets tired from playing Minecraft, from digging, building, and fighting with creepers, usually he goes to play with his dog, and after that he goes to read his favorite book, Harry Potter. And I believe you agree that both Minecraft and Harry Potter book is the peak of the creativity in their field. And in inventions, we also have very known patents that are pioneer patents. But most of the patents are not pioneer. They are improvements. But the key is that the thing that for one company is only an improvement, for the other one could be a source of creativity, the source for a new good idea. And this source could be a start for a good collaboration, because it's always better to collaborate, to get partnerships, to get friends, but not to get into disputes. So thank you very much for your attention.
Thank you. Thank you, Ieva. Any questions from the audience? If no, may I ask one question? Do we have Lithuanian patents on games?
No.
Not yet.
Only on classical game, one classical game, football. But it doesn't have anything with...
So again, I would wish you next year to receive the first patent application for the video game. Cool, thank you.
One of the latest news regarding Nintendo right now is that they're filing a lawsuit against a popular game called Power World due to patent infringement. And the patent is throwing a spherical ball into a monster and making it your teammate. A person that is a future game developer, I consider this mechanic very broad and very I would say like jumping essentially. It's very, not very specific or not very innovative because it's used in multiple games before that. And the patent was released in 2021, if I recall. Is there any protection in the patent law that prevents these type of very broad patents spreading and like, I don't know, like double jumping or like any other like basic mechanics being patented by certain companies that could lead to even more lawsuits? Is there any protection on that?
It always depends of the parties of the dispute. Because, as I said, patents have limits in time too. So a lot of companies, they just seek for lapsed patents and use these technologies. Because if technology is like lapsed patent, so you can use it free. So in these disputes, sometimes they say that it's not patented today. When I create it, the patent lapsed, and that's it. It's free. I can use it freely. The other side is about the broadness of the patent. And yes, it's difficult in such areas as pharmacy and the same in gaming sector. The abstracts of the patent is very, very difficult. And these disputes are very difficult because it's difficult to understand what are the boundaries of the patent, because every owner of the patent tried to write the abstract as broad as it's possible and to protect as more as it can. And yes, the best way in these disputes when it comes to agreement, some kind of agreement with license agreement and so on. But you never know. And the most interesting thing that we have some cases that the decision from USA court is one, and in the EU, the another. And sometimes absolutely different. So it's very interesting.
Thank you for your answer.
Because if the patent application is very broad, there's pretty good chance that actually it is, reflecting at least partially the state of the art. So I would say it may be questioned potentially because of the lack of novelty. Wouldn't that be the? So,
of course, every time it's depend from the strategy of protection and from strategy in the court to lapse the novelty of the patent, saying that it's new. And if in gaming industry, like these steps, they goes very fast, yes? Every day you can find something new and new and new. So yes, how to understand where is that is obvious for the specialist, today's specialist with the knowledge we have today, and what it's new. Yes, of course, the lack of novelty it's an argument, and it's the state where usually comes to court, and they try to lapse the patent according to this criteria: lack of novelty or lack of inventive step.